Overruling a decision. A superior court may overrule the decision of a court below it and therefore change the law. Today, our Supreme Court can use the practice statement of 1966 to overrule one of their earlier cases. We're going to explore this in much detail later on. I have got House of Lords / Supreme Court on screen because in the course, I'm going to be referring to the House of Lords quite a lot because some of the cases that I will be discussing were decided when we had the House of Lords and not the Supreme Court. It's important for you to note that since 2009, we haven't had a House of Lords, we've had a Supreme Court, but the same rules that apply to the House of Lords now apply to the Supreme Court. The Court of Appeal, you'll also learn, can overrule one of its previous decisions, but only if it falls into one of the three exceptions from Young and Bristol Airplane 1944. So generally speaking, the Court of Appeal should not be overruling its previous decisions either, but it does have some exceptions, and those exceptions are listed in Young and Bristol Airplane 1944. So we're going to start our discussion with looking at London Street Tramways 1898. And this case is a House of Lords decision. And in this case, we were told by the House of Lords that the House of Lords was not able to depart from its past decisions. So this is 1898. So I'm using House of Lords rather than Supreme Court because we didn't have a Supreme Court then. We had what we called the House of Lords. And they told us that they were bound by their previous decisions. So they could not overrule their previous decisions. Once they made a decision, whether it be 100 years or 50 years ago, according to the House of Lords in London Street Tramways and London County Council, they could not change that decision. They said there was an exception to this, and that exception was when they could identify that a precedent was made per incuriam. What does per incuriam mean? Per incuriam means that a decision was made without having looked at the relevant law when it was decided. But this was the only time that the House of Lords said they could depart or overrule their previous decisions. Otherwise, they said, if they reach a decision 100 years ago, 200 years ago, that was the law and it was unchangeable. Of course, there are benefits to our House of Lords being, well, now Supreme Court being bound by their previous decisions, because it means we have predictability and consistency in the legal system. However, there are quite a few disadvantages that occurred as a result of this strict adherence to precedent, as a result of the House of Lords saying that they were completely bound by their past decisions. Let's have a look at some of those disadvantages. The first one is that the law was not meeting societal changes. So the law was not able to change in accordance with changes in our society, because we had a House of Lords which said if we made a decision 100 years ago, a year ago, we cannot change it. Another disadvantage was that the law could not change wrong decisions. So sometimes the House of Lords did reach wrong decisions, but because they said they could not overrule their previous decisions, we were stuck with these wrong decisions. As a result, unsatisfactory decisions needed to be changed by Parliament. One example of an unsatisfactory decision reached by the House of Lords is that of DPP and Smith 1961. We're going to have a look at the facts of DPP and Smith and the decision reached by the House of Lords in 1961, and then we're going to see how Parliament changed it later on with the passing of the Criminal Justice Act 1967. So with DPP and Smith, we had a defendant who stole some goods. Now, in order to prevent him driving away with the stolen goods, a police officer leapt onto the bonnet of the car that the defendant was driving. The defendant now wanted to get rid of the officer. So what the defendant decided to do was to drive at high speed, making zigzagging movements in an effort to have the officer fall off the bonnet of the car. Unfortunately, the police officer was killed after he was thrown into the path of an oncoming car. That was unfortunate. The defendant was charged, and he was charged for the murder of the police officer. So at trial, at the Crown Court, he's there in the dock, and he is being tried for the murder of the officer. Now, in order for a person to be convicted of a crime, they need to have done the act in question, and they need to also have what we refer to as mens rea in criminal law. They need to have the guilty mind that is applicable to the crime they are being charged for or tried for. In his case, he was being tried for murder, and the mens rea for murder is the intention to kill or to cause grievous bodily harm or serious harm. Sometimes it is very difficult for a jury to determine whether or not a defendant actually had the required mens rea for a crime. The judge therefore had to help the jury to understand how they were meant to determine whether or not Smith had the mens rea for murder. And this is what the judge told the jury. The judge said, if you are satisfied that he must, as a reasonable man, have contemplated that grievous bodily harm was likely to result to that officer, and that such harm did happen and the officer died in consequence, then the accused is guilty of capital murder. As a result of this direction, the jury convicted the defendant of murder, and Smith appealed. He appealed, and first his appeal went to the Court of Appeal. What was his argument? He argued that the trial judge's direction to the jury was wrong. He argued that he could not be guilty of murder because he did not have the mens rea for the offense. Remember, the mens rea for murder is the intention to kill or to cause really serious harm. Go back to the direction that the judge gave the jury at trial. We will see that direction does not include any mention of the defendant's intention to cause grievous bodily harm or to kill the officer. We will see that it is quite an objective test in which the judge is simply saying to the jury, if you think that he must, as a reasonable man, have known that serious harm was going to occur or likely to occur as a result of what he was doing, then he's a murderer. And this was the problem that Smith had. He had a problem with the fact that the direction that the judge gave the jury included an objective test, not a subjective one. And he argued that the mens rea for murder fell under a subjective test, a test which asked whether or not he, as the subject, the defendant, had this intention to kill or to cause grievous bodily harm. The Court of Appeal accepted Smith's arguments, and they applied a subjective test to the case. His conviction in the Court of Appeal was changed from murder to manslaughter. But then the prosecution appealed the Court of Appeal's decision. Where did that appeal go? To the next court up in the hierarchy, which was at the time the House of Lords. And the question before the House of Lords was whether the mens rea for murder was subjective or objective. And what do we think the House of Lords said? The House of Lords actually gave us an objective test. They said that in law there was irrebuttable presumption that a person intends the reasonably foreseeable consequence of his acts. So the House of Lords was in fact telling us that defendants will be presumed to have the intention if the consequences of their acts are reasonably foreseeable. There is nothing in there which asks us to question the defendant and his perception of what he was doing and his intention. This was an objective test, and it was a problematic test given to us by the House of Lords. Fortunately, the decision was rectified with the passing of Section 8 of the Criminal Justice Act 1967. But let us remind ourselves of why we are looking at this case. We're looking at this case because we are exploring how overruling works, being that overruling allows a superior court to change the law, to determine that a previous precedent is no longer applicable. Remember, London Tramways told us that the House of Lords could not overrule their previous decisions. And I'm trying to get across to you that this was quite problematic that we had a House of Lords that could not overrule their previous decisions. This is an example of a bad decision reached by the House of Lords, and as a result of London Street Tramways' rigid rule that the House of Lords was not able to change their previous decisions, this decision sat on the law books until Parliament was able to change it with the passing of Section 8 of the Criminal Justice Act 1967. Fortunately, Parliament did step in and change the law, and they told us that in any offence requiring proof of mens rea, a court or jury in determining whether a person has committed an offence shall not be bound in law to infer that he intended or foresaw a result of his actions by reason only of its being a natural and probable consequence of those actions. So that was in direct opposition to what was said by the House of Lords in DPP and Smith.